I hope the first part of our forum took longer than expected. Plus, the center of any city has problems like traffic jams that you can find anywhere in the world. And I believe not all government officials have been able to have their lunch and arrive, and we expect them to come later. People who are here in this room, why don't we start working right now, and everybody else would join us later. So let me now use my authority as the moderator to explain once more the agenda of the roundtable discussion. I have to apologize right away. I hope that the organizing committee I know the organizing committee has done everything to have this conference held in the center of the city, and they have done all they could so that we could hold this session in this historical building newly renovated. But there are advantages and disadvantages to this. For instance, air conditioning here is not operating in an uninterrupted way. Let me still hope that we will be effective in what we do here without paying too much attention to what I mentioned before, especially as we are more than lawyers here or specialists in government regulation of subsoil and mineral resources. We are people who work with the mineral resources, and we are the ones who know all the pretty things about working in the field and how easy or difficult it is to work in the field. Okay, we are beginning. First of all, let me inform you that based on the results of the organizing committee's efforts, we managed to pull together some proposals or recommendations that we would like to let you know, and proposals we have received have been analyzed by us, and we would like to have them discussed. First of all, I hope that we would have a direct dialogue here. Speakers or panelists sitting before you are outstanding specialists, highly respectable ones, and I see people in the room who are very well versed in the usage issues of the subsoil, and we will have a very good Q&A session after the speeches, and we will give every opportunity we have to let people speak. To begin with, I'd like to introduce the issues while we are putting our equipment in good working shape. So this is for the slideshow. Just a couple of moments for the equipment, for the technology to work properly. And can we control this ourselves? Okay, the lower button. Fine. This modern technology, you know. Okay, let me draw your attention to the fact that today the mineral resources nowadays that are abundant in some, not all countries in the world, they are of special importance. And in this connection, I'd like to say that as we discuss mineral resources, in the context of sustainability of the global economy, we mean that mineral resources are distributed components that are essential for the development of the human society. Following from this quotation or definition of the object of regulation, it follows from here that everything we use is heavily reliant on how well we are provided with mineral resources. And in this connection, mineral resources including water, oil, gas, other hydrocarbons, other resources, they are obviously a very specific commodity or object of regulation, and economic laws and methods of regulation to regulate these things are very important. And since we're all professionals here, as we discuss the price, quality and cost in the condition where we have no policy, those would be just economic terms. But, well, in theory, just imagine it is not warm outside. Just imagine it is minus 50 or minus 60 outdoors and you have no electricity or heat indoors. Everyone understands this is more than economics or economy. This is policy now. Or even geopolitics. And I'd like to remind you all about these things as we start this discussion. Besides, it is quite natural that all efforts, all that we do on the subsoil, that is a national level problem. But mineral resources that we produce have to be transported and sold, and it is part of the chain of the processing system. So it obviously is an international product in itself. And it is very important that today's lawyers, legal experts, have included that as have identified this as something worthy of a separate roundtable discussion, in order for us to look at some deficiencies in the cross-border regulation that we obviously see today. By the way, you see this on the screen that we want, whether we want it or not, mineral resources today for every nation deserve a lot of special attention. Just for instance, the example of the Russian Federation. Today, if we look at the GDP of Russia, the mineral resources, all in all, account for about 40%. Which is a huge amount. Talking about the revenues of the Russian budget, that would be even higher than that. 60% comes from mineral resources. Also, there's a 4 billion rubles worth of what we get from the use of the subsoil, which is an evidence to show that mineral resources for this country are very special. We have not completed the transition to the new economy so far, and it could only be completed once the government does not participate in production anymore, instead doing a regulation without interfering with production. Unless we have achieved that, the transition period will continue. On hydrocarbons, we sell $148 billion worth of hydrocarbons, 4.5, and only 30 billion is all resources apart from oil, gas, coal and uranium. Russia produces a minimum of $300 billion every year, and that is the money for us to these are the resources that produce a very heavy impact on the environment and biosphere. I'm mentioning this because we are holding this conference in Russia, and Russia has a very specific kind of economy nowadays, and these things should be self-explanatory. Also, today we need to take into account, as we look at how to build legal relationships between consumers and producers, the relationships inside the production sector, what kind of competition we should have there. We need to pay attention to specific things about the Russian mineral resources sector. For instance, as we look at standard principles of doing business internationally. For instance, We need to understand that as you work with the subsoil, with mineral resources, it's like we need to distinguish between normal physics, so to say, and quantum mechanics. Some very clear, easy to understand things about molecules and atoms in the real world we see are very different from what we see in the quantum world. And we need to understand that there are certain specific things about the Russian mineral resources sector which make it different from normal economic regulation principles or laws. And that should allow us to what are the reasons for my saying so? Firstly, we need to understand that the processes here are processes that take a minimum of 5 years and a maximum of 20 years or more from start of exploration to obtaining the marketable goods, including all the interim stages, exploration, prospecting, production, processing, low value-added products, high value-added products. This is a very lengthy process, and the markets for these products are cyclical markets. As you build a new mine or a Stockman deposit for gas, you need to understand that over the period in the world, there would be at least 2 or 3 cycles in the global market of prices going up or down. Who can economically predict that or analyze that? What kind of return on investment would be by the time you have completed your project? You can only rely on projections, therefore. Also, the technology cycle in itself is quite a complicated thing. Whether we want it or not, it consists of individual links in this chain. Should one of those drop out, whether you have a bad investor and you know that the main thing for a businessman is to find a good partner, a reliable partner. That's 90% of success if you have a good partner. And that's a real problem, because throughout this cycle, especially for large investment projects weighing billions of dollars, we cannot possibly count on having just one even if best investor. We have to rely on more than one investor and partner. Also, if you look at the securities market where production companies operate, I can say that I'm also interested in these things. This is kind of hobby of mine, and I can say that market is absolutely obscure for me. Why? Profitability or EBITDA margin for the company A grows by 20 to 30% today, while the prices for the stock of the same companies would at the same time drop by 20 to 40%. This is the kind of drop we can see today. Why is that? I don't know. Maybe companies are not willing to go public or be public, because what does it mean, being public? It means you need to be able to offer the market an alternative. If you have some available capital and you want to place it, you face an alternative. You either go to a bank to invest the money hoping for the maximum return, or you should buy some stock for long of a firm for at least 1 year, and the profitability of that capital would be the indicator that even the London Stock Exchange or Toronto or any other exchange in the world would not be used. Why? Why is that? Because of speculators and banking entities who earn those margins, and those are actually bubbles. We need to understand that. That's a problem which is very acute today. You know what is going on in international markets today, and it is very important to understand how you can possibly escape from this difficult situation. And the specificity of legal regulation of the mineral resources sectors are things relating to the amount of investment. Where else can you find an object except for this world where it is not millions but dozens, even hundreds of billions of dollars? Those are things that make us take into account things without which you cannot possibly raise this kind of money. And the payback period would be a minimum of 10 years. And we need to understand these things have a direct relation to the success or failure of the project, and that heavily depends on the business climate. The investment or business climate and creation of a comfortable business climate is essential, and the money is the quickest thing in the world. You've got an idea, you click the button, and your money appears in another country where it is more comfortable for the money to operate, where it is more beneficial for the money's owner. And we need to remember that at all times. In this connection, I'd like us all to understand that we need to look at international regulation, although it is difficult to do this because of the things I try to mention, and moreover there are some international problems today, and unless we have pooled our efforts internationally, we won't be able to implement things at many large deposits. Do you remember 2 years ago, America, as it was defending its shelf deposits, said we would never uncover shelf deposits. But then the US faced a serious problem. And that made, and by the way, that's one of the best companies in the world in this sector. Even that company was not able to reduce the risks, to mitigate the risks. And the catastrophe in the Gulf of Mexico showed to the global community that there are no trifle things about this. The human factor plays not just an important role, but it is really essential and could be very dangerous unless you have taken it properly into full account. And I think we need to discuss all these. Also, there are regions, especially shelves, where for natural reasons there are some controversies, there are some disputes, like we see in the East, where we see disputes between South Korea and other countries, neighboring countries. There are some controversies and disputes. There are many controversial things, especially about the shelves, that are quite doable, that is possible to handle. But the main thing is whether we have in the world some international standards that allow us to legally work in disputable areas like shelves. And I'm happy that mining engineers, for instance, I met yesterday the president, a former officer at Total, and we talked about some discussions in that sector, and it appears we're only taking our first steps, and we're discussing serious things like Barents Sea, large shelf deposits with the participation of Subsoil, shelf areas around the American continent, but actually we don't have any standards or rules in place, international ones, that would provide for the required safety, including environmental safety. Those are not in place yet. And interestingly, it seems like a paradox. During the G8 or G20 meetings, all things would be discussed, but not the things that allow all nations in the world to develop. Those things have never been raised, to my knowledge, and there is no an intergovernmental body in place who would provide legal support to things such as accessibility of investment, migration of large investment to this or that priority investment project in this sector. These are the problems that, in my opinion, should find some coverage in our today's discussion. Therefore, I'd like to use this opportunity to set forth some few points, things that I, as moderator, we need to take into account during our discussion so that we really understand the economic and social environment and the legal framework that would be operational in the world shortly. As you look at this website, here, this page shows us some specific things to take into account. First of all, this is on the left-hand side, producing countries, and on the right-hand side, consumers. With those specific features of those, we need to realize that the producers of mineral resources, the general trend is such that, in theory, all those nations are quite rich. On the per capita basis, those nations they produce much more resources than anybody else does, but unfortunately those economies and the relationships between those and the global community are such that it is not beneficial to have those countries developing fast. As a rule, those economies would be lacking transparency. There would be a lot of corruption, bribery, and those problems give us reason to believe that in theory, those countries are very rich, but in practice, those are poor.
На этот слайд посмотреть, что, как правило, это действительно рабочие места, но их мало. Ну, вы знаете, анекдот даже существует, вокруг скважины места мало. Кроме этого, это элементарный передел, как правило, первичной переработки. Затем это, прежде всего, спрос на обычные кадры. И хочу сказать, что здесь максимальное воздействие на экологическую среду. Максимальное. Если посмотреть потребителей, то...
When we talk about the consumers, then the share of the human resources in the processing sphere is the highest. In some technologies and some industries, the ratio is 100%, and we should understand that these are the countries which buy the raw materials. They create and construct state-of-the-art processing complexes, and they are focusing on nanotechnologies, pure materials, and state-of-the-art medical technologies. These are the markets which attract the smartest and the best educated people. And in addition, the economy focusing on the primary sector, nevertheless, is aimed at enhancing the efficiency of production, and this production of mineral resources is also environmentally sensitive. If you look at this, and I would like to draw the participants, the attention of the participants to this slide, and if we talk about the raw materials markets, what are the development trends? Here you can see that the raw materials play a very great role in the stability of any country. Here you would see that in the near future, most mineral extraction companies would very soon lose their sovereignty, and in the very near future they would become transnational, multinational, and they would be focused on those areas which are the supply markets, or focusing on the markets and countries which are primarily producing countries. At the same time, we expect the increase in the demand on oil and gas and hydrocarbons generally, and we believe that the increase in demand would be over 20% in the next several years. And another sphere of interest would be various alternative fuels. And we should understand that the Caspian Sea Basin, Venezuela, and Africa, and those the areas where we expected the oil production to expand and grow. At the same time, these areas would suffer very serious political and economic risk pressures. It is linked to the activities of the so-called transnational companies, which have actually globalized the raw materials markets, and the world markets of raw resources have already been divided actually between such companies, and we'll know which of the companies is controlling this or that part of the world, and we know the names of such companies. Besides, the traditional countries that provide hydrocarbons to the world, that's the Near East and Middle East, this region is very unstable, and we have to understand that this time of instability will continue for some time in the future, and we understand that we've got to look into our own resources and develop them. On this slide, you would see the following. The oil and gas producing countries, and actually during the plenary session in the morning today we heard a lot about the mutual cooperation between the countries, and we heard a lot of such things said during the G8 and G20 summits and during Eurozec meetings, and all these countries they call for lifting the national barriers, and everybody supports this idea. Certainly all the countries still have their own national interests, and nevertheless from the economic point of view they call for economic transparency. And speaking of China, India and other emerging markets would play still a greater role on the political arena, and we've got to take into account their influence. We hear lots about the development of Europe and a lot of positive and negative things about the use of the nuclear energy, but in truth we see the fear of nuclear energy and the trust and confidence in the nuclear energy. They have certain limits, and according to experts, the trust in nuclear energy will drop drastically in the very near future, and so that would boost the demand for gas and oil. And whether we want it or not, this is the reality. And also we should mention the very sharp competition in the sphere of raw mineral resources, raw materials, and oil and gas, and that would certainly increase further the instability in the world, and that's something that we can forecast. And I would like also to demonstrate to you one geological site. Here you see a unique chart. As a rule, we do not publish it, and we are not talking about it very frequently, but this is the location of the largest transcontinental oil and gas area. oil and gas province. And so we can say about any unique fields in Sakhalin, and there are some fields which are located very close to Alaska, but we've got to understand it quite realistically. And experts, geologists, just asked me yesterday to demonstrate to you this chart. So in this geological province, we see over 70% of world reserves of oil and gas. And so the people are working in this area already, but certainly we've got to bear in mind who would be developing this area in the future, and this is the information that you've got to take into account. You've got to understand them. If we analyze the Norway's interests, then you see then the Caucasus, the Middle East, then down in the southern eastern side, that's the Caspian Sea, and so you know perfectly well how quiet those regions are. And so if you place geographical maps of those countries over this map, so you would see how we should react. And so oil processors asked me to demonstrate to you this information. So today, a lot is being said that OPEC and a group of oil companies, a lot of those that we know, and plus some other companies like De Beers, they are ruling the world. And so I would give you this small chart. So this is the synthesis which is essential for our operations. Otherwise, we wouldn't be working with coal and shale gas in the future. And so this information was presented to me by our colleagues from Siemens. And so this is the technological process, depending on shale and other rocks. And so if we think that the oil developers boost their prices on certainly depending on different currencies and their values over the past 10 years, so we saw the increase in gasoline prices by 15%. That's the average world prices on processed oil, gasoline. And certainly various nations introduce their excise taxes, etc. But again, let's take drinking water. Drinking water is again manufactured, developed, and poured and bottled into plastic bottles. And plastic is not very environmentally friendly stuff. And so again, if we compare the prices for bottled fresh water, which previously cost 30 cents per 1 liter bottle, you see the price over the past 10 years has risen several times. And so if you compare 1 liter of gasoline at the filling station with 1 liter of plastic bottled water, which you don't very trust, the quality of it is not very high, you would see the difference in prices and the difference in quality. And so this cycle between the oil and gas production and the consumption by the end user, this is a very, very long cycle. And so we've got to take into account various complexities related to the technological process. And finally, I would draw attention to the following. I have analyzed all the proposals which have been submitted at our forum, and I have grouped them together in this chart, and I believe that that's something that we are going to discuss. So generally, point one is that we have plenty of resources, fuel resources in the world, and so there is no crisis as far as the availability of such resources goes. As for the accessibility, physical accessibility, and the development of of such fields. That's another thing. And at today's forum, we've got to specify where we require legal support in the sphere of raw minerals production, and that applies to those countries which lack appropriate legislation but have appropriate resources, and it applies to those countries that would like to buy and consume. And it's important not just from the legal point of view, it's important for the survival of those states. As for the global oil and gas reserves, I've said they're quite normal, they're sufficient, but we need a legal support and legal regulatory mechanism, be it under the aegis of G7 or G8 or G20, whatever. There should be some mechanism that would provide support to those countries that on a voluntary basis have signed or would sign appropriate agreements. And if we don't have that in place, then we certainly would have very irregular supplies of oil or gas from the respective areas. A few words about alternative fuels. Truthfully, we've got to understand that in the next 20 years, we should raise the efficiency of oil or gas production by reducing the metal intensity or some other ineffective technologies. And in Russia, for instance, annually, due to our carelessness, we waste resources worth of 450 million equivalent fuel. So 450 million tons of oil equivalent. And we produce and extract 600 billion tons of oil, and so 2/3 of such resources are wasted due to the lack of efficient mechanisms for the processing and use of such resources. Just when we transport extracted resources to the processing facilities, then we lose lots of oil and gas and other mineral resources in transit to such processing facilities. And those figures which I quoted, these are in the public domain. They've been published in in various magazines and mass media. But speaking about other oil and gas producing countries, maybe the figures are even higher. And finally, I would speak about the availability of labor force. And I believe that today, when we speak about the various cycle-based activity and industry, and it's also linked to the other cycles in economy. When we talk about the mining and oil and gas industries, these are very science-intensive industries, and here the competition is very, very sharp. And so what is being used very widely right now, all the new materials, all the new technologies are immediately introduced into the industries. That's the situation in the world. We in Russia are importing new equipment, new tools, new machinery, and we even didn't notice when we lost our national facilities, the national plants and processing facilities. We are equipping such facilities with foreign-made equipment, and so we have already lost our nationality here, our national sovereignty, so to speak. That's something that we have, and so we've got to ensure that the management of such companies, that the management of such process technologies is very highly educated, and this is a matter of labor force. So we've got to attract appropriate labor force into this industry. Yesterday I met with experts from the geological institutes, and the experts told me that lots of companies are ready to invest millions and billions of dollars into new technologies, but not a single country in the world has invented a tool, a vehicle, a device that would force bureaucrats and government officials to pass through some qualification tests that would verify their professional appropriateness for the jobs positions that they occupy. And in Europe now we see various dollar and euro fluctuations, and they are also linked to the mineral resources that we're talking about. And that's something that we're going to discuss today. Now I would like to pass the microphone to the first speaker today, but I would like to mention that I wanted just to summarize during my opening remarks those proposals that we have already received after the first session of the forum, and I also outlined some matters of principle that my colleagues from Russia, from Europe, from Canada asked me to raise. And so my Canadian experts, for instance, specifically requested me to focus on those points which I have highlighted. We hear a lot being said about statehood and government regulation and other matters, but we've got to remember that among the pillars of any state, we should mention the mineral resources. And in the UK, for instance, you remember some time ago when there was a crisis with gasoline prices. What would happen in Europe if there were some blackouts of electricity? And I remember in Paris, I was in Paris in those days when there was just a total blackout in several districts of Paris, in Paris. And so you understand how people would react. There is no electricity, there is no heat, and there was no lights, no traffic lights. Just life stopped. The telephones were not functioning well, and it was just a very small malfunction in the delivery of this mineral resource, this fuel, to Paris, which lasted for a short time, but nevertheless the repercussions were quite serious. And this is something that we have no right to forget, because we're talking about the future economies, the future civilizations. We're talking about the survival of the global civilization. And so I would urge all the participants to join in our discussions and share their ideas and thoughts on such points. And I would like now to give the floor to the Ministry of Mineral Resources, Mr. Senif Lamonosa, of Minister of Mining and Energy of Burkina Faso. And I hope that Mr. Minister would speak about the development of their national system of mineral resources management.
Thank you very much. First of all, I would like to thank the organizers of this forum who allowed us this opportunity of talking about my country, to tell you about the development of legal support services for the subsoil exploration and use in Burkina Faso. I unfortunately was a little bit late. It took me a long time to find this room. Burkina Faso is a continental nation that has 6 neighboring countries around us, and we have quite a lot of economic opportunities given the climate we have in our country. Starting from 1991, Burkina Faso, like other African nations, has been developing its economic development program, focusing on the development of the private sector. As regards the subsoil in Burkina Faso, that is a sector that is really essential for us because we do have certain resources where the government acts as a regulator working with private businesses, and accordingly in 1997 we had a first code adopted or enacted on subsoil use, within which all companies have been operating. In 2003 we had a renewed code adopted. We have 7 mines operational at this time, and our national law follows the generally accepted principles in that. This law that regulates subsoil use allows the government to act as the regulator. However, the government doesn't hold all the leverages to fully control the activities of private businesses. In 2003, we had this code enacted, which consists of 129 articles, stipulating the key principles of this regulation. Section 2 of that document contains 2 very important articles which regulate the transfer processes, the licensing processes for the development and production of mineral resources in Burkina Faso. The state tries to behave in such a way that the licenses are issued on a tender basis. Gold mining is one very important sector. This is one of the riches of our country, a very important one, and Burkina Faso. And the licenses that the government issues for the production of mines and quarries, those licenses are effectively not securities. However, other articles of the same piece of law, Section 3, for instance, that contains 7 articles, it sets forth a number of very important principles, such as the principle of compensation for the development of the deposit, while regulating some issues relating to local communities. For instance, if a development relates to the need to relocate some people who used to inhabit that area, that has to be regulated. Also, the code has articles dedicated to the environment protection issues and making businesses responsible for the recovery or rehabilitation after the completion of the development and operation of the deposit. Other articles in the code set forth the principles of taxation, in particular VAT-related issues, and VAT is that activity is subject to VAT, and some other taxes are incorporated there as well. At the stage of development of a deposit, the government will look at will make sure that the taxes payable by the company be taxed in such a way as to be in line with the rules that exist in the whole of Africa. For instance, those established by the Central Bank of Africa, Central African Bank. Also, there is a tax on the profit earned from deposit operation, which is approximately at 25%. Its rate is approximately 25%, and some other taxes payable there, such as the personnel training tax. And let me use this opportunity to say that we are really interested in collaboration with Russian companies. Russian companies have already worked gold mines in Burkina Faso, and we're thinking about developing another gold mine by a Russian company. And I believe that should be
le risque doit avoir l'opportunité donc de pouvoir transférer et de faire le champ qu'il veut sur le territoire national et selon les règles de la BCEAO. Le titre 6 traite donc des droits et devoirs de l'administration des mines, notamment le fonctionnement du cadastre minier. Parce qu'au Burkina Faso, ce qui nous caractérise, c'est que nous sommes informatisés, il n'y a pas de risque d'erreur. Lorsqu'un permis est octroyé, il ne doit pas normalement avoir de double attribution. Le titre 7, qui comporte 2 chapitres, traite des infractions et sanctions, des procédures de constatation des infractions et du règlement des litiges. Parce que, comme vous le savez, il faut des droits, il faut des devoirs dans chacune des parties prenantes au contrat. Voilà pourquoi ce titre-là donc explique comment est-ce que lorsque vous êtes en infraction, on doit pouvoir donc vous sanctionner, ou lorsque l'État est en infraction, comment vous pouvez donc attaquer ou rester en justice avec l'État si vous le voulez. Et le titre 8 donc comporte des dispositions transitoires et finales. Alors, si on doit revenir sur le résumé des avantages du cadre législatif de notre pays, il faut dire que les avantages essentiels du Code minier du Burkina Faso sont l'exclusivité des titres de recherche. Je crois que Norgold peut témoigner. Ils ont environ plus d'une vingtaine de permis de recherche où ils ont l'exclusivité donc de travailler, de faire la recherche. À eux de pouvoir donc, j'allais dire, organiser et j'allais dire l'intervention des orpailleurs sur les sites. Et lorsqu'ils décident donc que des orpailleurs ne peuvent pas intervenir sur les sites, l'État donc...
Нет, я должен реле слышать. And invocation of licenses, and where the work is not complete at a mine or deposit, then the government may may grant an extension to continue geological exploration or survey. And we believe that this kind of partnership, that is a win-win situation. Of course, as you invest billions of dollars, or as you discover, as you strike a deposit and then the government says go away, that would be not fair. The government does think that you are entitled to work on this or that deposit or mine. This is only about providing such an operation where if a relatively small company discovers a deposit, there must be an arrangement in place or a regulation of the transfer of rights to maybe a larger company who has a greater capacity to work it. And also, this is about our collaboration with our international partners so that we can carry out such transactions and operations together. And the government allows operator companies who may be indebted, they are free to open bank accounts in offshores if they find it suitable to make up for the debts they had incurred when working the deposit. And in this regard, the government also provides, in my opinion, the necessary conditions for businesses to stay in Burkina Faso. The dividend policy and the invested capital distribution and asset sale policies in place, and the freedom in dividend policy really exists. But let's not forget that Burkina Faso is situated in such a place where mining companies must first depreciate the costs of exploration and inception phase before they can start paying out dividends, which is quite important to understand, and this is quite fair. And we believe, I'd like to call on you and ask for your understanding, because we believe that, of course, I'm not a lawyer myself, I'm an economist by training, but I do believe that arrangement was not invented for mining companies, you know, and I think that maybe we could think about a more reasonable arrangement for this particular provision, instead of the one that exists today, which I think is not always very effective vis-à-vis mining companies, especially when it comes to their relationships with the government. Free access to hard currencies, stabilization of the tax regime, these are again important advantages of my country, and the tax arrangements that I had mentioned before. So there are a whole number of tax and customs provisions as per the Mining Code of 2003, which I think are very attractive, and it was they who made many large companies come to Burkina Faso. We have 7 gold mines operational at this point, but we still believe the mining complex, the mining code of 2003 is already obsolete now, because a code is something to develop, and therefore we decided by now to take efforts to have this code adapted or modified to make it best suitable for the current environment. The future code will not only retain all the advantages you see in the present one, but it will bring more advantages to our international partners. And it would not be good for a country like Burkina Faso to have a situation where the mining companies become very rich while the government is not. So we think that amending the 2003 code should come as a result of a dialogue between ourselves and our partners. That should be a bilateral process. And as I said before, we have many advantages, including in the taxation area. And to conclude, let me say that an investment of this type must be large, and governments do not always cannot always afford that. That's why we're inviting private partners. Another thing is a risk of that investment. The government is not able to do that, and it entrusts mining companies, your companies, with doing that. And finally, mining resources are not renewables. And that's why they think that the very period of existence, the life of a mine, is limited, relatively limited, and the nation, the government, should be getting something good from that mine, including the local communities. And finally, we need to take into account the environmental impact, and the new code will include the respective provisions, such as one covering the issues of recovery of the environment once the mining company has left it or while it is still there, because we want to know what would be done after the mining operation has stopped. We don't want to have barren land or contaminated land instead. We have some precedents where companies would come to us, like in 1975, to withdraw in 1991 when the mine had been depleted, leaving just a desert around it. And we also need to know that companies and the government should help create community development funds to be invested in by both businesses and the government. Those would be economic investments and also social investments. This way, local communities would understand that they would win from having this kind of business in their land. What is the task for the government here? Of course, we need to develop a state-of-the-art mining legislation. We need to fully understand all the risks. We need to understand that this is a very important factor for our economic development, and the code of 2003 is being amended right now. But again, that should be a process to be done in conjunction, in collaboration between the government of Burkina Faso and the businesses operating in my country. There's a huge potential for job creation at the level of 20,000 jobs or so, which means billions of KFA francs, replenishing our national budget, which is very important for my country. And of course, it's also a human problem, because many people work there, and that is the way for them to survive. And because of this, Burkina Faso is in top 5 of gold-producing countries in the world, and soon we will start mining for zinc ore, and hopefully shortly we would be able to issue new licenses for new mines. There were a lot of gossip and information about new deposits, and soon that will be done. Thank you for your time. Well, there was some information shared, and there has been some information shared, and let me be the first one to ask a question. Obviously, every nation that has got some mineral resources, whose economy lives off that, it tries to build good relationships with producers that would be not only for the best interest of today's interests of the nation, but it is also very important to protect investments. I know the government policy in Norway, for instance, or Australia, BHP Billiton for one, was informing me of that, and I think that, and what I would say is a benchmark is the Canadian policy in mineral resources, including metals. From this perspective, it is obvious, Mr. Minister, that your country is very rich. But do you have full understanding today that the subsoil regulating legislation, civil legislation or otherwise, do protect investors coming to your country who wish to do production or manufacturing. Before answering your question, let me say that, of course, the authorities in Burkina Faso have paid a lot of attention to foreign direct investments in our country, and it's been 5 years that in April and May the government allocates a day to meet all large investors in our economy.
And certainly we understand all the necessary interaction between various government authorities and agencies, because any government involves some red tape. And so, for instance, when you know that in the Ministry of Mineral Resources in the ministry responsible for the mining industry, they have certain problems in their respective areas. And so we raise such questions at our meetings between ministers. But I must say that our law, subsoil regulations, they do protect the investors, because, well, these laws and regulations, they are not changed in favor of this or that minister or this or that prime minister, because, well, the same provisions apply today which applied yesterday, and the same would apply in the future. And so we are talking about the sphere of protecting our interests. And when in 2010, for instance, we saw the increase in gold prices, there were conventions signed related to the increase in royalty payments. I believe that such conventions are being observed. In other words, we have not changed the rules of the game. Even if the situation in the markets change, we do not change the rules of the game, and any investors that come to Burkina Faso, they are protected by our national legislation, and it's very serious. What's the position of the world community on what can be used as in the sphere of processing industry as instruments of partnership? Let's not forget about the fact, and actually I've mentioned that in my opening remarks, that my country is an enclave located hundreds of miles from the seashore. We certainly do have our problems, and the energy prices are very high, and you know that energy industry and gold mining industry consumes lots of electricity, and certainly we've got to invest a lot into the electricity grid. But in order to invest this money should be provided by somebody, some other sources. Another thing, when we talk about processing of mineral resources, you know that in my country we produce millions of ounces of gold, and certainly it's not only my country that should be looking into such problems, but maybe just a number of African countries, of Western African countries should join in. And certainly we do have very rich resources, but we certainly have certain weaknesses, because my country has started serious economic development quite recently, and certainly we do experience a deficit of energy resources, and certainly the same applies to the processing. Any other questions from the floor? Just don't forget to introduce yourself. Deputy Minister of Natural Resources and Environment of the Russian Federation, State Secretary Popov. I have the following question. Our moderator, Mr. Litvinenko, raised a very important issue, which first and foremost related to the type of regulation which is most appropriate in the sphere of subsoil management. Whether such regulation should be based on civil law or on some administrative law issues. You have described your subsoil regulation and the civil code, and so we can presume that you are improving and perfecting administrative legal regulating factors rather than perfecting civil law vehicles. So what do you think, which of the two, administrative law regulation or civil law regulation, is the more effective when we talk about subsoil management? Thank you for your question. I'm not a lawyer, but nevertheless I will try to answer your question. I'm not talking about my country, Burkina Faso, currently, but I'm talking about all other sub-Saharan countries, and certainly we are first and foremost talking about the administrative legal regulation, because we've got to provide the most favorable conditions for the activities of our partners. But as for the civil law legislation, you know that our civil law legislation is based on the Napoleonic Code, which we still apply, but nevertheless we try to modernize our civil legislation so that all investors coming to my country feel comfortable. And I always say that all investors that come to us, they come to us not because we are so beautiful or attractive and all the countryside is very beautiful, but the investors come to Burkina Faso because they believe that they can build partnerships that would be profitable to both parties, to all the parties concerned. Any other question? Thank you, ladies and gentlemen. It's not a question that I have to ask of you. I just wanted to thank Mr. Deputy Minister who raised his question, who addressed his question to us. It's very important to understand that Burkina Faso has opened the first private mine only in 2001, and maybe it's too early to speak about profits. It will take time, but even the code of 2002 and 3 would be subject to amendment and amplification, and we will be doing it several times, and so we will be improving the regulation in the sphere. I would like to say another thing. Let's say Mongolia is also relatively rich in deposits and raw materials, and the USSR in its time also provided advice and recommendations to Mongolia about how to manage their subsoil resources. But then, sometime later, it turned out that we are not up to scratch here, and we cannot teach other people about how to run this business, and some other countries who have their own history in the sphere of mineral resources development, but they still certain problems relating to subsoil regulation, and Barrick and Intergold and some other Canadian companies, they are working and operating quite successfully already on their respective international sites, and they are using like moon technologies, and it's very impressive. But nevertheless, they still have problems relating to the interaction between government authorities and the subsoil developers. And again, when there are some political reshufflement, and it affects the activities and operations of companies. That's the experience of Mongolia. And certainly from the very first day of developing a major field or deposit area, its investors and operating companies should have very clear ideas about the rules of the game. And certainly taxes are important, but this is not the main criteria. But the most important question is how well all the investments are protected, and because this is the key issue for trust and international renommee also of the subsoil resources user, of the developers, of suppliers, etc., and of the hosting country. And this is a major international issue. I, for instance, can praise some African states that are quite successfully improving their relations with investors. I can praise De Beers company and some other areas where we see some positive developments in these African states. But another danger is the monopolization of some specific countries where major companies would like to work in. We're talking not about the immediate interests, but about the prospects for development in 20 years' time or 30 years' time. And I hear comments from experts about the regulation of there would be more questions, and now I would like to give the floor to the next speaker. This is Deputy General Counsel of Global Corporate BP Group, whom I mentioned several times today, Mr. Andrew Haynes. And we heard about some wishes that partnerships should be covered. And maybe we would ask Mr. Haynes to mention the regulation in the offshore projects, because we know that you are one of the leading companies in the world here. Thank you.
Thank you, Rector Litvinenko. Would anyone mind if I stood for my presentation? Could I have the microphone? The microphone? Is it working? Is it working? No? Turn it on.
Sorry, I cannot hear you from that microphone. No, I cannot hear you.
Here, maybe I can use this. No, I'll just sit down here. That's fine. No, it's just. Sorry, everyone. I thought it may be more interesting for everyone. I could stand up and refer to some of the charts, but I'll try and be equally lively sitting down. May I offer my thanks and appreciation to Rector Litvinenko for inviting me to speak. For me, it's a great pleasure to return to St. Petersburg, which I haven't visited since 1985, when I was a Canadian student on exchange here. So it's a great pleasure for me to return to see this beautiful city and to see how much progress and prosperity has emerged over the last 25 years. And so thank you very much, Rector Litvinenko. I thought it was very impressive that Rector Litvinenko was able to, in 10 minutes, list about, and I noted them, about 25 of the major issues that we're facing in the international oil and gas and mining industries, and the great public policy and commercial challenges we all face. And I thought it was also very interesting that the Deputy Minister from Burkina Faso was able to speak about the need for partnerships between governments and the private sector in order to create benefits for all of us. And so today, what I hopefully, following in their fine footsteps, will be able to discuss with you is the need for new partnerships in the oil and gas sector. I will just pull up my own set of slides here. The oil and gas business has been marked by many partnerships. Sorry, everyone. There we go. The oil and gas business has been marked by many partnerships over the years. And you'll have to excuse me for one moment because I can't see the slides. I just need to pull up my own here. These partnerships will become ever more important for some of the reasons that the Rector mentioned, and that is that global energy demand is going to grow enormously in the years to come. We at BP annually publish a very comprehensive review of world energy demand and supply outlook to 2030, called Energy Outlook 2030, which put together by a team of our economists inside BP, which provides a great deal of detail, and I would offer for you to see our website at BP to refer to our Energy Outlook 2030. But in short, we forecast an enormous increase in demand for energy, up to 40% more over the next 20 years. And at the same time, the era of easy energy, as we put it, is over. There will be declining oil production from many traditional basins, and we're going to need to be finding new forms of energy. And what will be a greater challenge for us is that going forward, the oil and gas that is to be found and extracted lies in many more difficult places. It is offshore, it's in the Arctic, it's in very deep basins, it's in places with high temperature and high pressure that are difficult to produce from. There may be a lot of hydrogen sulfide, as you find in Kazakhstan or other places, a great many challenges. And these great challenges also involve great complexity in terms of how you may seek to explore and produce, and equally great risk, as we've seen from the Deepwater Horizon incident in the Gulf of Mexico. Because if you're operating offshore, if you're operating in the Arctic, there can be great risks that if things go wrong, it's very difficult to contain these dangers. And this is very, very different from the onshore, simple oil and gas industry that we knew 30 or 40 years ago in Russia, in Canada, in the United States. Just to give you a picture of demand from our Energy Outlook 2030, to put what I've just said in graphical terms, you will see that we are forecasting annual oil demand to rise from approximately 8 billion tons per annum, rising out to 2030 to approaching 16 billion tons per annum, most of that growth coming from non-OECD countries, from growth in Arab nations in South America, increased economic activity in Russia, and a great deal of it in China and India. And if we ask ourselves, well, where is this increased energy demand going to come from? Well, we can see that there will be probably a substantial growth in oil from 3 million tons to 4, an enormous growth in gas, still a large and probably growing role for coal, especially in China, and the great hopes for energy supply that we had in recent years, hydro, nuclear, renewables, face their own challenges. There are limits and environmental limitations to hydroelectricity. Nuclear has been brought into question, as the Rector mentioned, especially following the Fukushima disaster, which posed great risks for all of Asia, and also renewables. While we hope that there will be breakthroughs, we in BP are investing a good deal of money. The growth in renewable energy is not emerging as quickly as we may have hoped. So, reflecting on this and asking, well, how have we dealt with demand for energy in the past and ensuring that we supplied it in the past? Well, in the past, we had a situation where the knowledge of how to find and extract oil and gas was in the hands of a few companies. They were known in some literature. The gentleman who wrote the prize referred to many of these companies as the Seven Sisters. But in effect, you had private companies known as international oil companies or IOCs dominating the oil and gas business because they possessed most geological and petroleum engineering skills, and they controlled most global oil and gas production. And in many respects, governments were dependent upon them. The one great exception to this, and this is of great compliment, was in the Soviet times. The Soviet Union had its own public, very experienced, very deep, extensive oil and gas industry that was not private, but my remarks are more aimed at a Western audience. Of course, over time, others learned that they didn't need to rely upon private companies. They could have their own geologists, their own engineers, and so governments developed their own national oil companies, and in the 1970s, especially, we saw a great deal of nationalization and resource nationalism that changed and continues to change the industry. We've seen the recent nationalization of YPF in Argentina in only the last few weeks. And governments were focused very much on controlling the right of access and maximizing their split of production and revenues. And to be fair, this was probably a fair response by many governments to what were often unfavorable commercial arrangements in circumstances where they were quite comfortable taking over exploration and production and continuing to produce energy for themselves. But we're entering a new era, and the era is it's not so easy to find the oil and gas anymore. It's not so easy to produce it anymore. And no one company, no one government has all the technologies required, the experience required in order to access these new resources. And if we're going to go offshore into the Arctic, to high temperature, high pressure frontiers, we need to work together in new partnerships to get the right mix of economic returns, of efficiencies, of technologies, of development of local economy, of development of the right supplier bases, of economic benefits for the local community and for the host government. And this means we need to work together. And my thesis today is that we will achieve much more collectively than we can individually, and that we need to find new, more diverse and more creative ways of bringing together our assets, resources, capabilities and technologies in order to meet this enormous demand for energy that we'll see in the future. Oops. Now, in considering the elements that we will need to consider in structuring new partnerships for oil and gas, I thought it may be helpful just to list a number of things which have been mentioned by the Rector and by the Deputy Minister, which are important in structuring any comprehensive legislative framework, in structuring any comprehensive commercial arrangements or any comprehensive set of supplier arrangements to deal with these new complicated oil and gas exploration and production challenges. And firstly, of course, there's upstream access, title and access to oil and gas acreages and resources, which is the prerogative of the sovereign state. There'll be risk capital which is needed, because we must remember in exploring for oil and gas, most oil and gas exploration actually fails. It's the minority of efforts that find commercially discoverable and producible reserves. And so someone has got to spend a lot of money and take a lot of risk to find commercially producible oil and gas. Of course, we need to make sure there's appropriate subsurface expertise, geologists, geophysicists, petrophysicists, petroleum engineers and the like, which, as the Rector was mentioning, is going to be a great challenge for the future, as so many people will be retiring and we don't have an adequate supply of people with the right experience that have come through the pipeline because of difficult times through the 1980s and 1990s. We need, of course, solid petroleum engineering expertise, project management expertise in managing projects involving many suppliers, many interfaces, tens of billions of dollars of expenses. Increasingly, and I can say this because I oversee intellectual property matters for BP, we have enormous intellectual property issues. Many key technologies that are required are the subject of strong patents, and there will often be required very complicated licensing arrangements or contracting arrangements to get access to the right intellectual property. Of course, people are always concerned about the right to book reserves in production and assuring that they can get physical offtake to sell it or trade it in the market as they wish. We need to be sure that there's access to transportation capacity, which will in many countries be under the control of state-owned companies for very good reasons, and while everyone should respect the right of the state to decide how they control transportation, there needs to be that access to capacity in order to allow for upstream exploration and development. Otherwise, the oil and gas won't get to market. Of course, there is refining capacity, which was more of an issue in the past, but still in certain locations may be difficult. I can think of Canadian heavy oil and the limitations that have been placed on development of heavy oil in Canada by the lack of refining capacity and the challenges they've had to overcome to find that refining capacity in North America. And something that's often overlooked, but I can say working for BP, which is the largest hydrocarbons trader in the world, that oftentimes there's a great deal of benefit to be had from very strong marketing, trading, and optimization of oil, gas, and liquefied natural gas. And that's something that people often don't think about till the very end, but actually very strong plans and strong partnerships addressing marketing, trading, and optimization can benefit everyone. And of course, in a world where we need to depend on so many suppliers who own the key technologies, you need to have very strong supplier relationships and strong supplier relationship management skills to manage those suppliers properly, to get them to deliver things efficiently and at low cost. And that is a skill in itself that needs to be thought of in structuring partnerships. I thought I would try, and maybe this is, instead of the Deputy Minister being an economist speaking about the law, I'll try and be a lawyer speaking about economics for a moment. But to try and put a picture on some of the concepts that have been discussed by the Rector and by the Deputy Minister, I thought it may be instructive to, in one very simple graph, take a look at what a typical oil and gas or mining project will look like. And in very simple terms, anything above the line is a profit or a revenue. Anything below zero is an expense. And you'll see in a typical arrangement that you will have, and I hope you can see with the laser I'm using here, you will see in a typical arrangement that in the early days you'll undertake exploration, you'll spend sums of money, and if you decide to then develop a field, you will have to spend much larger sums of money, and this is money that's being put at risk that the development or exploration may not work. It's money that's being put at risk that the government may take the asset away, as just happened in Argentina with the YPF assets. It is money that may be put at risk because maybe, as the Rector was mentioning, the commodity price cycle turns and suddenly prices change and what you thought was going to be a profitable investment is no longer. But this is the fundamental issue that we all grapple with in the hydrocarbon sector, is that, and in the mining sector, we have to invest an awful lot of money up front before we even begin to see any revenues, and we take on enormous risks of the sorts I've mentioned and the Rector was mentioning. Over time, hopefully, you will see substantial revenues, and then as an oil and gas field comes on to peak production, just given the geological nature of fields, you can only produce so much at a time, and then you end up drawing down the production over time. I hope you can see that. You draw down production over time until the field needs to be decommissioned. The short story of this is that you can't make all your money in one go. You can't produce all your oil in one go. You can't provide the benefits to the local community in one big bang with the snap of the fingers. This is a long-term partnership. It's a long-term relationship required in order to produce to explore for, develop the hydrocarbons, produce them, deliver them to market, and share the benefits. And it means long-term relationships, long-term partnerships. I can provide very, very quickly just a few examples of how BP is trying to engage in new forms of relationships beyond the traditional ones. A simple one I can mention up the front we've entered into with host governments is the exploration and production sharing agreements we've entered into with the government of Oman for the gigantic Kazan and Makaram fields, which contain probably in excess of 7 trillion cubic feet of gas. This was gas that actually the Omani government, their state company PDO, found. They didn't need us to find it. They have a great deal of capability in PDO. They have many, many capable Omanis. They have their own gas infrastructure. They have their own LNG plants. They did not need BP at all, except for one thing. The reservoir had such tight gas, it's so complicated to produce from, that they needed someone with the expert technology to frack and to produce from tight gas reservoirs. And so they held an auction, and BP presented the best technical case and the best commercial case, and we entered into the production sharing agreement with the country. We're right now doing an appraisal program. If we go ahead together with the Omani government, we're going to be drilling over 300 wells in the Arabian Desert, and we hope to produce 1 billion cubic feet of gas today, producing Omani gas production by a third. This is an example where we're working in partnership with the Omanis in order to try and bring best technologies and best practices in order to unlock reserves that were locked to them since the 1990s. In India, again, a very capable local company, Reliance Industries. It's not a state-owned company, but it is a national champion, a very strong Indian company. Again, very strong technical capabilities, a lot of economic resources. They didn't need BP, except for the fact that, again, they were having some great challenges with reservoirs and thought that we could help them to better manage very complicated reservoirs that often produce a lot of sand in deep water offshore India in order to help them maximize gas production, which India so desperately needs. And so we acquired a 30% stake of all of Reliance's offshore oil and gas blocks. And while Reliance is the operator, we have joined them as a very strong technical non-operating partner, and we have a 50-50 joint venture for the marketing of gas in India. And we're hopeful that this will see great benefits both for this state champion as well as BP over time, and most importantly, cleaner energy and a more regular supply of energy for the Indian people. Another example that I think is of great interest that I thought I would share with you is how private companies are now pooling their expertise for greater safety and greater environmental safety, and that is following the Deepwater Horizon incident in the Gulf of Mexico. Exxon, Shell, Chevron, ConocoPhillips, and BP joined forces to try and develop technologies to be able to contain a well blowout and prevent an oil spill like the Deepwater Horizon from ever happening again in the offshore. And we knew that no one of us could come up with the best solution alone, so we formed a company and have shared all of our intellectual property, all of our patents, all of our know-how, and put in many of our best engineers to develop the best technologies. And again, this will make for a safer industry and a safer offshore industry, and we welcome the participation of others in order to try and develop improved technologies to make for safer offshore exploration everywhere. And I should emphasize that the MWCC is, of course, a non-profit organization, which is a great departure from how Shell or Chevron or BP may have dealt with things in the past. We want this technology to be available at cost for anyone who wishes to access it. So this then leads me to try and bring a local flavor to this discussion, to suggest that perhaps there are a few things that may apply in the Russian context if we're going to have new, more sophisticated, more dynamic, multi-party partnerships for the development of oil and gas in Russia especially in the Arctic and especially on the offshore continental shelf. And this is principally, as other speakers have mentioned, the need for a stable and secure legal framework for frontier exploration and development. This is especially the case because offshore is expensive, it's risky, there'll be long payback periods, and those people are going to invest, whether they be oil and gas companies or whether they be lenders or whether they be other sorts of investors. They need to know that there's legal stability and security. And someone had asked earlier if it mattered whether there was an administrative law instrument or a law. I think having worked in 27 or 28 different regimes around the world, there are many different ways to try and address this problem. The fundamental point is that whether you do something administratively or by law or by contract, at the end of the day, there needs to be a comprehensive set of arrangements that everyone can have confidence in that will work to provide stability. And I'm not saying that there can't be an emphasis on benefits for the state. I'm not saying there has to be too much money for the private companies. I think that that can be the subject of a negotiation to arrive at a balanced outcome. But what there needs to be is a sustainable and stable set of arrangements that everyone understands at the beginning and that will still be in effect at the end of the life of the project. And here I want to give a great compliment to the Russian Federation with their recent efforts to try and provide tax stabilization for offshore projects over a 15-year period with the new administrative act issued in April of this year, and Russia is to be complimented with efforts to try and provide greater tax stability. As both the Rector and as the Deputy Minister mentioned, there needs to be an appropriate risk-reward balance. Those people who invest in oil and gas projects are, of course, nowadays investing globally. People are no longer focused on one country anymore. People invest globally. So projects now compete for investment capital on a global basis. And international oil companies, their shareholders and lenders, need to be able to demonstrate competitive returns on capital, taking into account the chances of success, which of course will be lower in the offshore and lower in frontier basins, and the long payback periods that may be associated with large projects. And when you consider that there will be a lot of expensive dry holes in frontier offshore exploration, there needs to be an appropriate or commensurate return for taking such risks. And here I may give you the example. I've done a lot of work in Brazil. Petrobras, for example, had to drill 110 offshore wells in the Santos Basin, deep water wells, before they found the large pre-salt commercial discoveries that they're now developing. And 110 offshore wells is an awful lot of money for anyone. I hope that in Russia, the Russians have superior technology and superior geology. Maybe they could do it with 30 or 40 wells, I don't know, but still there'll be a great many challenges and a lot of expense associated with developing any new basin. And that brings me to my last point, which is the need for the right technology and the right experience for undertaking frontier offshore exploration. There are many strong companies in Russia, especially Gazprom and Rosneft, who have many, many years, decades of experience with large projects. But I think, as the Rector mentioned, there is value in involving people with deep offshore experience, whether it be in the Gulf of Mexico or Brazil or the North Sea. There's value in involving companies with the right reservoir management technologies, with the right environmental and safety technologies to deal with containment of well blowouts and containment of oil spills. And again, I think if we can bring together the best that Russian technology and Russian industry has to offer with international technology and industry, I think that this will be of great benefit to Russian Arctic and offshore exploration. And I'd be pleased to answer any questions you may have. Thank you.
Well, I'd like to say that I feel deep respect to what that company has done, knowing what it has done, especially working with non-conventional deposits and sources. I have just one question for now. You, as a specialist, as far as I understand, well, we have known each other since quite a while ago. what do you think? Entering a large project like Stockman, clearly the government, well, Russia is financially stable now, but do you think that a government guarantee is a must-have thing for a large investment in a project like that? I know what people could think about. Recently, I read a report from some Americans who suggest to urgently create some international regulator involving some voucher capital so that internationally, such as an international bank, could provide some safety guarantee for such investments, providing guarantees through venture capitals, which would be mandatory for a country who has failed to sign this or that agreement. I'm referring to the WTO talks. Is it possible in theory? What do you think? And secondly, would you approve of that? Thank you.
It's a very good question. I think that there are, if I may, a few aspects that you've raised that are worth discussion. Sorry. Right.
Okay. No. Okay.
Rector, yes, that's a very good question. I think you raise a number of important issues. Trying to take them in turn, I think, taking your last point first, I think for the WTO to try and come up with common standards or to regulate how capital investments may be secured, I think is a great challenge. I mean, there was an effort along these lines with the Energy Charter Treaty. I think there's been some very limited success of the Energy Charter Treaty, and I'm really not sure the Energy Charter Treaty has really provided anyone with much more comfort, and I'm not sure that a similar effort by the WTO would. If I could offer, without naming the country, some off-the-record examples, I mean, I've been involved in projects where, frankly, there really wasn't a contract that was followed. But the government was reasonable and understood that we had to make a reasonable rate of return at a former, not BP, but a former company I was with. And we understood that sometimes they needed extra revenue or needed extra investment and gas production to deal with some of their social issues because they were dependent upon gas for power generation in their country. And I can say that over time, they asked us to give more, and we did. And over time, we would say to them, we need a greater return, and we got that. And because there was mutual trust and respect over more than a decade, actually, that worked just fine. But for other countries where you have maybe a history of aggressive executives or political instability, and I could point to Bolivia being a classic example, or where maybe there's been some aggressive administrative action, as I've seen in Kazakhstan in the past, then maybe you want a little bit more security. That could come in the form of treaty protection, either BITs or the Energy Charter Treaty, which maybe Mr. Volterra could speak about. Equally, it could come through contractual protections or the involvement of multilateral agencies such as the American Development Bank, OPIC, World Bank, etc. I would say that what will often work best is first and foremost trying to get the right contractual or license arrangements that are balanced and sustainable so that everyone can be comfortable that they are getting the right share of benefits and the right share of risks. And also at the outset, so there's a sustainable framework at the outset, because if one person is not going to be happy in 10 years, that's not a sustainable arrangement. You need something that everyone is prepared to live with for a long time. But then involving multilateral agencies and having treaty protections all as part of a package can provide greater security of investment and would make, and this is the important point that I would make, the cost of capital and availability of capital easier. To answer the first part of your question, I think that having a multilateral agency supply venture capital can be of assistance, but frankly, it's not going to be plentiful and it's not going to be cheap. I mean, ultimately, governments can, it's up to a sovereign how they wish to regulate. It's up to a sovereign how they wish to establish their hydrocarbon regime, and everyone must respect that. But the way in which a government chooses to regulate, or the way in which they choose to create a license regime for hydrocarbon exploration and production will mean that they may have access to more capital or less, or may have to pay a higher interest rate or a higher rate of return or a lower one. And the more stable, and the more secure, the more transparent, the more sustainable the regime, well, the more capital will be available and the cheaper it will be. And so I think that it's probably not feasible to create a multilateral agency that could fund developments of the scale of Stockman. That's an enormous, very complicated project. But perhaps an involvement for an element of the financing may have benefits. I don't know. I will admit that I looked at Stockman and put in a bid for Stockman with my former company, but I've not been involved since because, of course, Total and Statoil have entered. The particular case of Stockman, I would say it's important to distinguish between risks that companies are happy taking and risks that they're not. As an oil and gas company, we are happy to take price risk on oil and gas because we understand it. People who invest in us are prepared to take price risk for oil and gas, and that's a risk we will take. We're prepared to take exploration risk, development risk, supplier cost risk because we understand and have some influence over those risks. Where we're less comfortable is when we're being asked to take political risk or change in law risk, because that's something that we don't control, but the sovereign controls. And that's where we have to look to a sovereign to say, how can you help us mitigate this risk in a way that still respects your authority as a sovereign to legislate as you wish, so that we can come up with a feasible project. In the case of Stockman, I'm not sure a government guarantee would make a huge difference. I think there, it's just such a complicated technical development from all I understand. I think that developments of that nature for gas offshore are just very commercially challenged from the outset. But please take my remarks as those of an outsider. You probably know the details of Stockman much better than I.
No.
Speaking about this field, the thing is that unfortunately we have too little time left for our round table, and so I certainly understand that would be other questions raised from the floor. I personally could ask dozens of questions, but nevertheless I would abstain from that because we've got to understand that Russia and many other states who are oil and gas producing countries, including those in the African regions. And I would say that the investment is coming into those regions. As for the risks, here I would argue, because, well, everything is relative. There are some bigger risks and smaller risks, and if there are risks but there are no laws, and certainly then the investor, if the investor wants to go into the country and start the operation, then it's the decision of the investor. And so a lot depends on the actual domestic environment. And we do have in Russia investment, and we do have investors that are coming in who are interested in getting annual dividends from 15 to 50%. And so this is the actual figures that we know at present. These are very high dividends. And so in retail and wholesale trade, you know, it's just from 7 to 10%, and here is just 15 to 50%. And so we're talking about major projects, and just in some situations, the government cannot ensure 100% stability due to the new elections and new governments coming to force. I know that just the of natural resources during the forthcoming G20 summit would be discussing such issues, and I would also be participating in the meeting, but we would be discussing the issues about some security or guarantee at the initial stage of development. So Stockman, for instance, is just is a separate issue, but so the government should perform the external audits and just will state that a certain amount of reserves, let's not go into figures, but nevertheless. And then there is an international fund, for instance, or a multilateral organization or agency that would provide venture capital and would provide insurance to all the businesses involved in such offshore projects. So this is the problem on the agenda. And in June in St. Pete's, during the G20 summit, we would be discussing such issues, and I hope that we would hear some proposals. And what I want to say, that partnership today, this is a #1 priority. And I also have certain something to do with business entities, and I helped a company to prepare for their IPO, and I certainly provide consultancy services, and so I understand the private business. And so I also served in the army, for instance, and it's very important in our upstream sector to feel the shoulder of your partner, because when you go and perform your task and mission, you've got to be sure of the persons, of the partners that you are doing it with. And so it's very good that we're discussing these issues and problems right now, because let's say 10 or 15 years ago, it was just impossible to learn that a BP manager or a manager from other major oil company would go to work to Rosneft or to some other Russian oil company. And so right now we know of such instances, and certainly such top managers are very important, and certainly they're worth a lot of money. But at the same time, being partners, we've got to be able to resolve those disputes which we inevitably may encounter in the process of our joint operations. And so now I would like to give the floor to an expert in such areas, to Mr. Robert Volterra. So the microphone is yours.
Thank you so much. It arrived. Fantastic. I have a presentation that is for a much longer period of time than I feel I should take today. And so whilst I'm being passed the clicker by whomever had it last, I will preface my remarks by saying, thank you very much, that if anybody wants a copy of this, you can let me know. And I am not going to speak to every slide that is present in my presentation, because it would just take too much time. I'm going to talk about investment treaties, or bilateral investment treaties, known as BITs. That's their acronym. And I'm going to talk about their relevance to the mining sector, but it's also, the comments I'm about to make are also relevant to the hydrocarbon sector. Indeed, they're relevant to any sector of foreign investment, but I've tailored them to the subject being addressed today. In essence, investment treaties, bilateral investment treaties, are based on public international law. So first I'm going to speak briefly about what is public international law and how does it have any sort of role in the protection of foreign investments. This is relevant to governments that wish to have foreign investment come into their country, and it's relevant to businesses that may be looking to make investments outside of their home country. And in essence, this is an attempt through international law, international agreements between countries, to establish a stable, basic legal framework for investments such as in the subsoil sector of mining and hydrocarbons. international law protects against what people in the business world often call political risk. Political risk is a way to talk about what happens when governments change laws or when governments take administrative actions directly or indirectly against foreign investments. It's a polite word that we can talk about, doesn't offend people. But it essentially means government activity or state activity, because it can involve courts and so on, that deprives a foreign investor of the benefit and use of their investment. That's essentially what it is. And people think of it most commonly as expropriation, but it covers a vast array of governmental, non-governmental state activity. And it can involve direct expropriation, for example, a government sending troops in to take over a mining facility. And it can involve indirect expropriation. Sometimes a government can intentionally or unintentionally interfere with the property rights of a foreign investor without doing it head-on, without sending, for example, troops in to take over the mine. It can instead pass a series of regulatory measures, the effect of which is the same as if the government had sent in the troops to the mine. International law protects against that kind of risk, and the way it does it is through international agreements. International law is the law that governs relationships between countries. It covers things like war and peace and the United Nations and boundaries. It also covers the treatment of foreign nationals by a state. So, for example, I am Canadian, I am in Russia. However Russia chooses to treat me whilst I am enjoying my stay in St. Petersburg is subject to international law. And it is open to Canada as a country at any point, if Canada feels I have been mistreated as one of its nationals, to complain to Russia and possibly to take up a dispute with Russia. Now, of course, that's not going to happen. I'm just using it as an example. That is generally part of how public international law works. Countries have to treat foreign nationals in a special way. They have to treat them better than their own nationals, and that's just part of the law. That treatment also applies to investments. Sometimes people have trouble coming to terms with this, but in fact, in public international law, a government has to treat the investment of a foreigner sometimes better than it treats the investments made by its own nationals. That's a requirement of international law, and there's nothing any of us in this room can do about it. That gives foreign investors, in theory, a significant degree of protection against what we call political risk. However, the problem in international law is that the only actors are other countries. Companies and individuals are not actors. They can be acted upon, they can be regulated, but they cannot themselves act. It's a bit like if you think about a farm and a farmer. Farm animals can be regulated by national laws, but farm animals cannot vote, they cannot sue. Farm animals belong to the farmer. If you are driving down a country road and you hit a cow and you killed it, you may have to pay compensation to the farmer, but you would not have to pay compensation to the cow's children or the cow's wife. And that's the way public international law works. If one country expropriates the property of the national of another country, in public international law, the damage is done to the other country, not to the company or the individual. So if a Russian company invests in Canada, and Canada directly or indirectly expropriates the Russian mining company, the harm that Canada did in international law is done to Russia, not to the Russian mining company. So you may say, well, why are we sitting here talking? Because we're dealing with ideas of governments and investments and private companies in the mining and hydrocarbon sector? Well, it's because of a phenomenon that I mentioned at the outset of my talk called bilateral investment treaties. Bilateral investment treaties are specific agreements between countries that set out the provisions that I just described of requirements of governments and courts of one country not to harm the foreign investors of another country. But they have one unique thing which makes them very special, and that is that almost every bilateral investment treaty allows the company, allows the investor to begin binding international arbitration against the government directly without requiring any specific consent from the government. And that is remarkable and unique, if you think about it. What these bilateral investment treaties do is they codify the protection of the foreign investor that I mentioned, and they allow dispute resolution mechanisms directly from the investor against the government. If those dispute resolution mechanisms were not provided for specifically in the treaty, then the company, the investor, could not start an arbitration against the government. And there are more than 3,000 of these treaties in existence right now. There's actually probably more than 3,500, and they're increasing at the rate of hundreds every year. There are agreements, for example, between Canada and Romania, between Russia and Gabon. I'm sure Burkina Faso has a number of these investment treaties. There are only a handful of countries in the world that have no investment treaties. North Korea doesn't have any. Brazil has a few, but they haven't ratified them. And the reason governments sign them is because they encourage foreign investors to come in, because they provide a stable legal regime against expropriation. They provide recourse. In the mining and hydrocarbon sector, one of the most important treaties is called the Energy Charter Treaty. That's a treaty that is a multilateral treaty with about 50 countries that have signed up to it. Russia was at one point. It is now withdrawn from that system, which has its own repercussions, which are beyond our discussion today. There are other forms of protection the public international law give to foreign investors. These relate to boundary disputes and state immunity. I'm not going to get into those today. But mining projects provide a good example of how public international law and these bilateral investment treaties can protect foreign investors, and governments must be aware of their obligations under them. Of course, they don't challenge the concept of sovereignty and governmental jurisdiction and, over natural resources. What they protect against is a change in the legal environment. They are more effective than stabilization clauses, which are merely contractual agreements. These are agreements outside national law. They prevent a government from changing the legal terms on which the investment was made beyond a certain degree. There is some regulation that is allowed. There's an acceptance in international law that there can be some changes in such things as health and safety protection, environmental protection, tax regime, and so on, but within scope and within limits. And international law can see through regulation that is intended to be expropriation but merely pretends to be slight regulation. There have been cases to that effect. For example, there's cases involving American investors in Mexico where the Mexican local governments wanted to get rid of the American investors and so pretended to change environmental regulations and were found in violation of their international legal obligations, and Mexico had to pay hundreds of millions of dollars in compensation for the effective and indirect expropriation of the foreign investor. There are a number of different types of international treaties that protect investments. I've listed them up here. They can be bilateral, they can be multilateral, They can be free trade agreements. Many free trade agreements contain provisions that also cover investment protection. As I mentioned, there are well over 3,000 bilateral investment treaties in existence, and they are increasing in their number every year. I described what they were, an agreement between two states. And what they do, as I said, is they provide substantive protections. They provide procedural protections, that is, recourse to international arbitration. And they provide a requirement for compensation. Now, each of these treaties is different, and I'm talking in general terms about 3,000 treaties, so each one might be different, so you have to look at each one whenever you're dealing with a specific country or issue or investment. But usually the compensation that is required is some form of a fair market value. And I've listed here some of the substantive protections for investors. I'm not going to get into these in any detail. Suffice to say that they are quite extensive. Russia itself has about 10 years ago established a model bilateral investment treaty. So that's the model that Russia uses when it negotiates with other countries. The Russian investment treaties are usually very good and usually provide protection for Russian companies when they invest overseas and for other investors when they invest into Russia. And the fact that Russia has signed about 45 of these bilateral investment treaties shows Russia's commitment to the rule of law and the protection of foreign investments. There have been a number of investment treaty arbitration claims brought against Russia. That in itself shows nothing other than Russia is willing to follow the rule of law and the procedures in the treaties. There's been a number brought against Canada, Chile, the United States even has these cases. There's nothing unusual about them. They're more like an administrative appeal process under international law. So there are 62 bilateral investment treaties that Russia has signed. 45 are in force at the moment. As I mentioned, Russia withdrew from the Energy Charter Treaty, which has its own implications. I have in my presentation, and you can get it if you want, a description of the various kinds of provisions that you can find in the Russian model bilateral investment treaties. I'm not going to get into these in any detail through restrictions on time. Very quickly, I've got some slides here dealing with how a foreign investor goes about starting and prosecuting an investment treaty arbitration against a government. It applies equally to governments defending themselves against these cases. And there's a number of venues and fora where these investment treaties arbitrations take place. The most popular one is at the World Bank. The World Bank has a special facility called the International Center for Settlement of Investment Disputes, or ICSID, ICSID in English or CIAD in French. And it is it's not a court itself, but it is a secretariat that helps our ad hoc arbitrations under these investment treaties run. I was in some meetings in Washington with the director of the ICSID Secretariat at the World Bank 2 weeks ago, and she confirmed that by no means is this something that's pro-investor or pro-government, that it's almost exactly 50% success rate for investors of all the cases brought before the World Bank. So states win about half the time these claims, and investors win about half these times. I'm not going to go through in any further detail. These show some of the increases in cases. You can see it's quite recent, the development of these investment treaties and the number of cases. And the coverage is quite broad about where this World Bank facility called ICSID is the countries that are parties to it. There are very few countries in the world that are not parties. I'm not going to talk about ICSID. I also had some descriptions about the rules, about the amounts in dispute, and about how an arbitration, one of these investment treaty arbitrations is conducted. But again, for the interest of time, I'm not going to get into that too much. An interesting slide here is that the disputes brought under these ICSID cases, an enormous amount of them, 25%, deal with oil and gas and mining. So about a quarter of the investment treaty disputes worldwide come through the sector about which we're talking today, which shows the effect of these on this sector. The remainder of the presentation lists a few examples of the recent kind of investment treaty cases that have been brought in relation to the oil and gas and hydrocarbon sector. I think that's probably a bit too much for today's presentation. So the takeaway from my talk should be that there is a legal regime that applies, whether countries want it to or not, to the protection of foreign investors in the mining and hydrocarbon sector. It exists, it's there, it's real. You can come to lawyers like me and we can tell you what the provisions of that are. There's a new phenomenon that's taken off in the last few decades called investment treaties. In addition to the protection substantively in international law, these revolutionarily allow arbitrations to be brought by investors against states when they've been expropriated or their property's been interfered with. Again, a remarkable development, and you've seen through the slides the increase in the amount of cases being brought against governments. And lastly, these investment treaties and the fact that almost every country in the world have them mean that investors, when they are going to make investments overseas, have the choice of using vehicles, investment vehicles that are located in countries that have investment treaties with the country of the target investment. So for example, I don't know at the top of my head where and with what countries Burkina Faso has investment treaties, but it will have some. But imagine there's no treaty between Russia and Burkina Faso. There may be, I'm just hypothesizing. If a Russian mining company wanted to invest in Burkina Faso, and it talked to a public international lawyer who looked at the treaties and said, I'm sorry, there's no treaty between Russia and Burkina Faso, that would not be the end of the story. The public international lawyer could say to the Russian mining company, there's no treaty between Russia and Burkina Faso, but there is, for example, a treaty between Malaysia and Burkina Faso. So Russian mining company, if you set up a subsidiary in Malaysia and that subsidiary makes your investment in Burkina Faso, you are covered. And that is an enormous tool both for the investor and the government, and both need to be very aware, both before an investment takes place, during the life of the investment, and if problems arise, what are the scopes of their rights, obligations, and benefits. Thank you very much.
Well, thank you for very valuable information. Unfortunately, because of the lack of time, I think we can only accept questions at the end. We've got a question at our website. When people heard about a UK specialist arriving, it's not a question actually, it's a commentary. I'm not given the name because Nikolai Valerianovich is present here. I don't want to add job to his officers. The commentary is this. Russia has taken many steps to transform relationships with mineral resources users while the state owns and bears responsibility for all the resources, and it's only given for use based on two principles, based on civil regulation or based on a contract between the government and the company, stipulating the rights and obligations of the state and of the user only in mining area, and that's it. And the second attempt was made to transform that into a civil regulation somehow, but we face the problem of ownership. As I remember the discussion first time when one diamond producer tried to obtain some loan, but then that deal was stopped because there had been no such regulation in place. And in that connection, we in Russia faced a problem. As soon as it's not a problem of a lack of regulator. It was an uncertainty because of the lack of specialists. First of all, we do understand, like any other country does, that there are two problems. First, a lawyer like yourself must be present at a company who would be knowledgeable in specific regulation of subsoil use. You must have someone trained as a geologist and then a lawyer. And the second problem is terms and international law that must be well known by those specialists. Roughly speaking, in Russia we have about 100 or 200 lawsuits considered by various courts relating to subsoil use. So we don't have even people to send to each such place to consider each such lawsuit, even in Russia. So that matter of regulation is so acute today, it's so super relevant for any transitional economy like ourselves, especially where mostly production is done without much of processing or refining. International experience is very important for us of how to adapt this country, this economy to proper international norms. In Russia, the subsoil is still owned by the state, is under the hands of the state, and in all probability that will last for long, according to the constitution. But it is not to say that the civil regulation is not to be conducted there. No, it should not. It should be done that way. It is a paradox where the subsoil is owned by the state in here or in Africa, but it doesn't cost a thing. You can value a deposit, but it is not an indicator of attractiveness. It may not be a ground for getting international loans, but as soon as a government makes it private, especially if it is a public company, it becomes a huge value. So it appears that there's no need to work with the subsoil. You just give it to some private business, you get a license, and on day two it turns into a super company. And I think some vehicle of government regulation must be used there, including when it comes to the form of relationship between the government and the business and the user. That is a cornerstone of the problem, because specialists who would take care of national interests are not there. We only have just a few of them, and the very system does not work properly. And that is a real problem, and quite frankly, with lawyers in front of me, that is your bread. That is a piece of cake. And that's something for you to do business on that, and that is wrong. I think you should rethink your ways in that. I would appreciate if you could limit your questions and answers to 10 minutes. The representative of the Russian regulator about improving of the legal support for government regulation, and I'd like to ask Sergei Viktorovich, Director General for the Center on PSA, Product Sharing Agreement Center. You remember initial attempts in PSA, in regulating PSA. Thank you very much, Vladimir Stefanovich. And dear colleagues, I'll try to be brief, given the lack of time. In February, one of the most important pieces of law in Russia was 12 years of age. The Subsoil Act adopted even before, 20 years, even before the Constitution of 1993. It stabilized the situation in the sector, allowing to address the key national challenges during a difficult period. Transition to market principles was conducted and licensing was established. Currently, key efforts in regulation of relationships are still focused on the system to distribute the titles on deposits, although oil deposits have been distributed at about 99% of classified deposits. The current licensing system allows to effectively manage the assets for various purposes, and first of all for exploration and production through application-based and tender-based approaches, but there are significant gaps in the regulation of the relationship for the reproduction of the mineral base and the management of the distributed stock of assets. This way, further development of the legislation should be paid to these two key institutions of the legislation. In doing so, we should not drop further day-to-day improvement of the licensing mechanism. Now, I'd like to focus in more detail on each of the two. Geological exploration is a foundation of the entire subsequent process, and the lack of regulation is a hugely adverse factor. The stock of liquid and interesting assets, most of all that legacy, Soviet legacy, very little replenished over the last 2 decades, and the leading mining companies have the stock for decades ahead, and they are not interested in investing at early stages. The government budget financing of exploration is such that the burden is mainly on the subsoil users. Only regional exploration is done by the government to find out new promising areas, following which further exploration has only to be done by the companies. So it is relevant on the one hand to improve the mechanism for doing exploration using government funds, while creating for the businesses comfortable conditions for developing poorly studied assets. Government contracts, including the public procurement law and a draft federal law on the federal contracting system, they fail to consider the specificity of the functioning of the geological sector. To address this, the legislation should include the following provisions. First, identifying the winning bidder based firstly on the technology, skills and experience without competition on price, thus avoiding dumping. The federal contracting system allows to use the tender with limited participation and establishing a 25% limit below which the price, the bidding price may not go down. And sole source procurement should also be allowed. Thirdly, the possibility of promptly adjust the geological terms of reference based on newly obtained information. Firstly, the procedure must be in place for derogation of the contract. That's about the government regulation measures and financing to finance with government money. Private investment now. A set of measures to stimulate the subsoil users to do exploration should include, as we think, simplification of the procedure for obtaining areas for geological exploration with private money, with the possibility of filing electronic applications. Secondly, establishing guarantees providing the titles for exploration to the party that had discovered it. Thirdly, allowing exploration at federal territories, federal areas. Fourthly, improving the procedure for obtaining geological information, including the electronic documentation and the limitation of the period of confidentiality. Fifthly, the one-off payment should be paid when commercial operation of the deposit starts. And finally, the geological exploration period on shore should increase from 5 to 7 years. To summarize, Unfortunately, the geology sector doesn't have a separate special law to regulate it. Enough to say that the current Act, Geology Act, the functioning only has one article on that. The purpose of drafting and enacting such a draft should be establishing the stock of deposits that could be used in the future. Another large block or module is how to manage the distributed or fragmented blocks. Government management should be made more efficient by using the particular blocks of deposits with more rational use and protection of the subsoil. One of the key instruments of government governance of the sector was doing government examination of technical projects to do deposits. The current Act on subsoil only provides for getting a permission from Rosnedra, and that may not be done without a full-fledged examination. So you need to have technical examination done and providing financing mechanism for that. Next, there is no system of legal regulation of doing government examination for geological exploration projects. We don't have the administrative regulation of Rosnedra to do government examination of that. Thirdly, currently the legislation doesn't provide for the sources of funding for that work for mothballing and liquidation. In case of liquidation or bankruptcy of the user, financial insolvency.
6. Well, such sites are maybe quite dangerous for the environment. Consequently, the government must expand budget funds in order to liquidate and phase out such sites, and this is certainly not sufficient. In order to resolve this problem, we propose to amend the existing legislation and create a special insurance fund or a system for insuring risks, and that would introduce the obligations, impose obligations on the subsoil users to recover the damage, remove the damage caused to the environment. Currently, we lack statutory methods to calculate the amount of damage. Article 93 is practically not used, and we don't have legal regulation of the account for and the maintenance of work performed at exploration well sites, and also those abandoned wells. And it's certainly very important to know how the situation stands with such wells when the soil users report on the use of their licensed areas. And consequently, our third block of issues, that's improvement of the licensing procedures. Here I would like to highlight several points regarding the perfection of the system. We believe it's necessary to change several grounds for classifying certain sites and areas of subsoil resources into the federally significant lands. That would cover some small deposits of platinum and also copper mines. This would help stimulate the exploration of highly liquid types of raw materials, first and foremost gold, diamonds, uranium, and platinum, and it would certainly should apply to those sites which do not affect the industry on the whole. Another question today is just to provide a license of areas of the mining waste, so to speak, because such waste of mining industry also a source of very significant resources, and there is no regulation that would cover the issue of the handling of such waste. It certainly requires the improvement of effective legislation so that such sites and plots could be effectively developed. This certainly would involve the issue or reissue of existing licenses and the changing of licensing. And it's necessary to perform regular checks, and such regular checks may be conducted only 3 years after the introduction of a new business or a new legal entity. And some users of subsoil resources try and use such loopholes in the legislation. They avoid implementation of their duties. In particular, after 3 years, they just change the title of the business, which is developing a certain deposit or site. The same applies to various debts that such subsoil resources users may have, and they just use this loophole and change the name of the company, which becomes a new legal entity, and so such debts should be covered by the government. And so, I would mention that lots of other problems that require decision and resolution have remained outside our discussions. And the thing is that the new subsoil management law cannot really address all the issues and the problems which emerged during the past 20 years. And so the new legislation must be focused on attracting new investments into various areas of subsoil management. Thank you very much. Are there questions? A question here? So I have to respond to these comments. I believe that this is a very critical presentation on the one hand. On the other hand, I would say that Sergei has mentioned all the main areas wherein our ministry has been working for several years now. It's sort of, you mentioned Article 51 is not working because there is no appropriate regulation about the calculation of damage caused to the subsoil resources. Yes, true, because we don't have a federal agency, a federal authority that would have the right to adopt such a regulation. We have prepared a draft law which has been submitted to the State Duma. It has been reviewed into the first reading, and it just will. The second reading hearing is pending. So this is already done. The second point. You know that Andrew Heinz has proposed a very interesting idea that legislation must be stable. And I like this proposal very much. And I'll explain why. You know that law is more static as compared to dynamically developing public relations. But at a certain stage, this law is progressive. But when the public and social relations go further, then the legal instrument must be either replaced or changed or amended. And so here we've got to trace very accurately when it becomes necessary to change the effective legislation. At the same time, we should mention that the amendment or change of legislation is done with a view to serving some specific interest or some specific situation, which is very detrimental to our national legislation. And this applies to the changes and amendments introduced into the tax administration legislation. Our tax legislation is the legal sphere which is changed and reformed more frequently as compared to other areas of law. It does not only mean that the tax law, the effective tax law, is not perfect and it requires amendment, but very often such amendments are dictated by specific situations. And so what do we have in the future? It means that we are constantly changing the rules of the game. And if we keep changing the rules of the game, it means that the players distrust us. And this applies to the international investors, domestic investors, and the lack of trust of the people, generally the people to the government authorities, because, well, we know that any law is two-sided. There is a Russian saying that it law depends on the user, from which side you view it and how you use it. So on the one hand, certainly you notice that we have various developments in the sphere of tax legislation. Lots of such changes and developments are quite positive. We are minimizing the tax barriers to the subsoil resources users. So what is the correlation between stability of law, of legislation, including tax legislation or subsoil management legislation, and the necessary dynamics of future development of legislation? And maybe another question to maybe Robert Valtera. You mentioned that bilateral investment contracts partially protect the investors' interests, and also international agreements on mutual protection of investments. I would like to know what you think about how they correlate, these two instruments. And second question, what do you think about mediation, in particular when we use it for resolution of international disputes in the sphere of subsoil management and use? I would. The thing is that we don't have much time left. What I would say about this presentation. I liked it because it outlined all the venues of activities and all the issues that we are addressing. And those questions which were asked of our panelists, certainly we will give them a chance to answer these questions, but don't forget that we'll need like 3 minutes, whatever, to discuss our general solution or resolution, because such proposals would be submitted to the G20 participants in the meeting. So maybe just a minute, we could stay here. Okay, can I say a few words? Certainly do not treat my presentation as criticism of the ministry. I understand that a lot of the issues that I raised in my presentation, the ministry has been working very effectively, and it's developed lots of regulations and draft laws and whatever, which I mentioned. This is not certainly the blame, the fault of the Ministry of Natural Resources. I believe that these are the very sensitive and painful issues that we face in our industry, and these are the issues that we face on a daily basis. And so this is something that I personally am very concerned about, that because we are talking about numerous organizations, supervisory organizations, inspecting organizations, etc., and those draft laws which are being discussed by the government and by our parliament. That's very good. Thank God that something is being done and the situation is being resolved. And right now we have the resolution, the April resolution of the Russian government, which sort of covers those areas, 4 different categories of licensed plots. And so, but nevertheless, again, the problem has been pending for 30 years or so. I can say the following. I discussed subsoil resources from the point of view of international context in order to go into specifics, but I assure you that within the framework of our deputy committee and industrial committee, we would get together very soon and we would resolve such issues at length. So because we want to enhance the market mechanisms and to make our industry cleaner and purer. And so certainly these are very burning points, and thank you very much for them. But now I would like to give the floor to a representative of a company who is working very actively not only in Russia but in other countries as well, including Kazakhstan, and that's the representative of the gold mining company Severstal Zolota. That's Evgeny Alexandrovich Tulubinsky. And I just urge you to be very brief. Thank you very much. It was a very interesting and informative discussion. I understand that we're very limited in terms of time. I would just make several remarks. I would say that it's very pleasant to hear views expressed by representatives of science, of the industry, of investors, and we understand that the developing mining companies are interested in establishing long-term stable relations in the sphere, and I would but since there are still quite high regulatory barriers in the sphere of subsoil management, and it means that those subsoil management barriers very often overcome or surpass the national level, and they become transnational. What I mean, when we worked in Kazakhstan, and if it's necessary to obtain a certain license or permit in Kazakhstan, in particular when we talk about the sale of shares and stakes, not only in the operating company but also in the parent company. And then since the Kazakh legislation doesn't specify the threshold level regarding shares and the stakeholdings, then we have to use other means and ways in order to effect the sales. And some of such ways and means they contradict the national legal framework. And I believe that if the barriers do exist, they should remain on the national level and should not surpass the boundaries and affect the transnational businesses and companies. Secondly, certainly the guarantees of stability are very important for us. And the period of such stability is the payback period of the project. Certainly, during this period of time, we would like to see unchanged tax regime. Outside this time period, certainly we can expect some flexible approach to such guarantees, and we are ready to negotiate the changes in the tax regime. And certainly, the third point, when we talk about the protection of investor rights, sometimes we would mention the unwillingness of governments to participate in the capital of developing companies. In most countries, we have such mandatory stakeholders, like in Burkina Faso, it's let's say such as a statutory share, and Liberia also has a 15% statutory requirements for state shareholdings, whatever. Anyway, this is a very important issue, because if a state wants to participate in the redistribution of profit, that's a mandatory requirement. And so we see that American, let's say, companies, in Mali, in the South African Republic, the dialogue with American partners are being renegotiated, and they are looking into the future. But it's very important that such governments should treat their participation reasonably, and this should be taken into account by commercial companies. So the government share or stakeholding should not be excessive or so high as it would prevent effective management of operations. So the stability, long-term stability of relations between private and public partners, and a rational approach to such public involvement. And the moderator mentioned that money is very fast, and we compete not only between markets are competing, but also the countries are competing among themselves. But investors are already examining various industries and are thinking which industry is the most attractive for investment. So there's a threefold competition. Thank you very much. And certainly, those questions that you have raised, certainly we may be discussed later on after we wrap up our discussion, but nevertheless I would like to summarize our discussion. Those proposals that we received from the steering committee, so I would just mention those responses, our proposals, which are very important for the markets. And so we're going to publish subsequently such proposals. And so today's discussion demonstrated how we, subsoil resources users and those who regulate the management of subsoil resources, are unprotected from international unlawfulness. No, I wouldn't use the word unlawfulness, but lack of international regulation in the sphere of subsoil management and use. And so in Europe, for instance, there are countries in Europe which are producing energy resources and consume energy resources. Right now, Europe is primarily consuming gas, and so that we see lots of criticism about Statoil and Norway that it's not working appropriately. But this is the question to European commissioners. Please demonstrate to us the main European Union document that would regulate illegal relations with the subsoil users. If you have a single fuel balance in the European Union. Yes, if you have it, then you've got to have a very clear idea which country needs more oil or gas, which country needs less oil or gas, whatever. So, and certainly it's not we, producers of raw materials and resources, must knock on various doors and trying to prove that we need such projects and we need such sphere of regulation. Such projects should be approved on the international level. So, because well, we're discussing our issues, but we are ready to conduct negotiations, but within which field, within which framework such negotiations should be conducted? That's another thing. Next, since the subsoil management currently is severely affected by the globalization trends and the economic crisis subsequences, that's really true. We're also concerned that today, against the background of sharp reduction of production, we see an increase in demand on fuel resources, and the absence of international regulator creates such a situation when companies have to phase out of their production spheres. They have to reduce their investments in the sphere of exploration and production because they have to rely primarily on their own funding, and so it's a major issue. Our cyclical development of the mining industry, of the oil and gas industry, it doesn't coincide with the market cycles in the trade sphere, and so we certainly can face a very difficult situation in 20 year
And there's a similar situation in the world with rare earth metals. 1 year of well thought out Chinese policies resulted in a growth at 100 times over, and we see a threat, and we see similar things. It's a real threat to some other sectors of the economy, including health. So today we need to realize that alternative sources, which today are provided with using politically driven factors such as shale gas, but it needs to be brought into the economy. Taxation, if America today can afford to exempt completely the taxes so that the shale gas, which is 100 to 200 gas, has the same value in production and in the market. That's great, but it's not possible for Poland or the rest of Europe. What are the implications of hydrofracking, or what is the chemical impact on the environment from shale gas production? That must be clearly and transparently discussed by professionals. Also, we point out the trends that take place today, and the issues raised by the panelists are included in our communique, that we need to establish level playing ground and protection measures for consumers and producers. I'm not going to repeat it all. Instability, uncertainty in the raw materials market, and we need to show that miracle is impossible. Overexpensive oil produced in the shelf must be expensive. Just an exploratory borehole onshore is for oil is $8 to $12 million each. For the shelf, it is 18 to $40 million per borehole, about 3,000 meters deep. When it comes to the deep water shelves, it's a piecemeal work. We at the Mining University show the model given by Total. It's 3,000 meters. Just imagine the price, the cost of construction and erection, and what kind of business and investment and social climate must be there for the investors to come and give you the money, so that 15 years down the road their children could gain some profits from that. It all must be addressed today. Well, the profit and the money will be only counted up 20 years from now. We have discussed all things in detail, and what in a nutshell we propose, we the lawyers, those who work for the higher authorities that be, and I know many governments where the regulatory mechanisms are missing, so we point out that international laws will be applied for the best interest for the best interest of the producers and consumers, and some measures are required to address legal issues and challenges, to mitigate risks, to protect investment, to provide insurance and guarantees for the businesses. These things have been traditionally mentioned all the time. To save time, I won't read it aloud. Why don't we accept this draft? We will finalize it to make it brief, and I think that needs to be done, because many roundtable discussions during today's forum could only result in hot air. I would prefer to have something practical, to have this document published. I have distributed this draft to all the panelists, all the colleagues here, because again, people who produce, people who work there, we all speak the same language. We all know what we need. Every businessman knows that, but we, unlike them, we know a little bit more, because this is a very specific sector. And finally, it is very comfortable for me to take a plane, a good one, better, not a Russian make. Although I'm a Russian patriot, but I prefer to fly foreign-made planes when everything is comfortable and nice. And at the takeoff, they say, fasten your seat belt and have a good flight with us, while informing me that there is a professional pilot in the cockpit. Just imagine if we do the same thing, but then there is an announcement for us. Okay, gents, we're taking off. We hope it's all comfortable and good for you, but one small thing to mention. The captain fell ill, and replacing him, we have a very good guy. He's a doctor, and using the automatic pilot, he will safely fly us from here to there. I would prefer that regulation of such specific things as subsoil use be paid very, very special attention, because that is a foundation for any politician, any leader of any nation, and that must be something really robust and realistic foundation. And in these things, the professional skills, the management and leadership skills are very, very important, because we must know that it takes a long time to come to terms with a professional, but once you have come to terms, it's very easy to work, which is very contrary to someone who is a sub-professional. I hope we will continue our discussion, and now if you have any serious proposals to make to amend the draft, I am ready to incorporate that. You can email us or otherwise. So, see you next, and if there are some questions left unanswered, we can accept them informally. Do you have a commentary or a question to make? You represent the minister? Yes, please. I don't have a question. I would just like to share my point of view. As someone who represents an African state, I didn't feel it very much in today's discussion, quite frankly. I paid a lot of attention to what you, Mr. Vladimir, said, saying that raw materials can be found in many characters and are very important for the nations. And you said that it was a specific commodity that should be subject to special regulation, and that is important in geopolitics. And that market has a cyclical nature. That is quite obvious for us. We do understand that. We, as a rule, I come from Guinea. We have 40 billion worth of bauxites, and the exploration is not over. We're only doing that. We may also have gold and diamonds, but the problem is this. It was very interesting for me to hear Mr. Yevgeny's question about the participation of the government. Indeed, we have drafted the new code in 2011. That is one of our priorities. We have mining resources, very important ones, but operation of those has not brought anything good for us over the last 30 years or so. One example is a company bought by Severstal, and before it was done by Severstal, we had no company from that Russian company. We had no profit from that Russian company, although all exploration had been prepared and the valuation was done, and all the money was counted up, and we never got it. And that was related to the activity of other companies, gold mining companies for one. And there are many other companies, bauxite producers. They have not brought enough of resources to fight poverty in my country and improve the situation. So as we participate in the, can I continue? If we are going to continue exactly the same way when we have no profits or very little profits as we have had so far, that is not right. We would like to participate. We would like to buy in those companies, and we were offered 15% of the stake. We were offered to buy 15% or maybe more, and known resources, explored resources, irrespective of what kind of funds are invested in the operation, those monies should not exceed the potential revenues. We think we are entitled to participate whatever the matter, without paying for anything for that, and that's a strength of our new mining code.
Our tax legislation is being developed even further, and all those revenues that which are connected to the sale of ore production. So let's say the same 15% would be paid back to the region where the site is being developed, and the contribution from the state is mandatory, of course, and the government should receive certain assistance from the operators, from the subsoil users. But the question is, let's say, to question then that those contracts that were signed in various African states more than 10 years ago, they're not very well balanced and not very fair in some instances. And so it's quite natural that the countries, the states, would start requiring that a certain portion of funds would be allocated to the states. So in Guinea, we would review all the contracts, international contracts that were signed over the past 30 and 40 years. Well, it doesn't mean that it would be a one-sided review. We just propose to have a multilateral or bilateral negotiations. We would get together at one table and discuss which shares, how shares should be split between all the participants. Thank you. So, I would also I would thank the speaker for his comments, because he professionally knows the sphere. And adding to the bauxites, when we introduced in the 1990s tolling schemes in Russia, and we ran into the same problems, and so the company which is buying, which is using and buying such materials, the government doesn't receive anything. And so tolling is a scheme which is used for, frankly speaking, non-developed states. And so we want to abolish the tolling schemes in the future. And so if the law is put together first, and then the contract is signed, while this law does not contain mechanism for implementing such contracts, this is nonsense. So if, for instance, let's say you would demand 30% of participation in the company, certainly you cannot expect 30% of profits basing on this contract, because, well, there are various ways and means of sort of diluting this and hide this profit, whatever. We had, let's say, a product sharing agreement with Sakhalin consortium, and it was on the face of it a very profitable arrangement. But why did we have all those scandalous discussions? Because when all the calculations were done, then we realized that Russia did not receive those benefits that it had been promised, but even had to pay, remained in the debt. And so we are talking certainly about direct government regulation that involves very clear rules, and without any participation of police, it may be a very good police force, but nevertheless, and we're talking about without personal involvement of ministers, prime ministers, etc. And I know your system very well, and I believe that the problem of state regulation is most topical. Recently I met the minister from Congo and from a number number of other companies, and I was really stupefied. How can you sign contracts with investors when such contracts do not contain provisions about obligations for such companies to invest in your national universities, that they do not send your students to Europe, America, whatever, to take higher education in the sphere, so that such students, upon graduation of universities, would come back to your country and work as specialists, and they would enhance your labor force. And certainly there are some contracts which have no provisions about training and education, about new technologies that should stay in the country. And so again, the same as with the product sharing agreement in Russia, we did not receive anything that has been promised. And I believe that's even if the contract is very good, even if it's signed by a world-known company, it's still this company signs the contract in its own for its own benefit. They are interested in the profits, and certainly that would be a problem for the hosting state. This is a very lengthy discussion, and nevertheless, I would thank you once again for the conversation, for all the experts that participated in this discussion. We have an open website, and we are open for cooperation with any company, with any government. Thank you.